So everybody, thank you very much. Good morning, good afternoon, good evening. Thank you for joining us. I'm Bojana Bellamy. I lead Center for Information Policy Leadership. We are global privacy and data policy think and do tank, and we operate out of London, Washington, and Brussels. I personally am in London at the moment, today, and normally as well. Who is CIPL? For those of you who don't know us, we've been going for about 20 years now, and indeed have started work on data privacy, cybersecurity, thought leadership, policy, but have expanded into wider data policy because this is really the reality that we live in today. Our mission is threefold. We are here to provide thought leadership, best practices, to enable us to deliver this fourth industrial revolution, this huge digital transformation of our society, but in a way that protects and thinks about humans, individuals, and individuals' rights like data privacy. We think both are important and can be achieved. Our mission is also to ensure better understanding, convergence, and interoperability between global legal regimes, because technology, people, uses of data are truly global and cannot be delivered through national policies and national lawmaking. And then finally, we very much believe that we need a new way of working in this new paradigm of digital between regulators and regulated entities, the one that favors constructive engagement and the one that favors also some innovative new ways of regulating through regulatory sandboxes, policy prototyping, and generally better transparency. I just actually finished a presentation to a group of sort of future board members on the expectations of boards. And this was exactly the discussion that the new digital world requires companies to be much more proactive and openly addressing their responsibility in the digital space, in the use and development of technologies, but it also requires regulators to work actively and understand where the industry is going, where the technology is going. And listen, this topic today is a really great example of our work. CIPL has been for years promoting organizational accountability. We believe organizations are responsible to put in place policies, procedures, leadership oversight, best practices to use data responsibly, to develop technology, products, and services responsibly. And in fact, privacy-enhancing technologies, privacy-preserving technologies are just a ultimate, Rolls-Royce approach, dare I say. It's a cherry on the cake of all the accountability, right? On top of everything, companies are now increasingly investing in creating technological solutions which are actually helping us preserve privacy while we are able to use data. So in some ways, they are a perfect solution to our problem, right? The problem of today's digital world. How do we ensure responsible, wide sharing, use, data transfers for benefit of everybody, for equity of all people, for equity of all countries, but in a way that also protects privacy and also addresses real concerns of people as well. So privacy enhancing technologies are going to be one of these solutions, and we want accountable organizations to invest and to develop or procure these technologies. Now, our project was a year-long project. Eden, who's been working on this, will tell you more about this. We've worked with privacy officers, with their technologists, with some of the vendor companies who are developing these technologies as well, with business leaders and regulators as well. And I think we had threefold objective. One was, how do we demystify and explain what these technologies do? They're not a panacea. They're not an ultimate solution, but they can help hugely, right? And that is very, very important. The second point is, how do we ensure there are real benefits in developing and using and investing in technology? So if this is going to help us with legal compliance, if this is going to take away some of the legal problem, then companies are going to invest more in this. And we need, therefore, thirdly, some incentives and some real support and encouragement and really leaning into by regulators into these technologies, and also enabling regulators to incentivize companies to develop and use these technologies. They're expensive. They're state of the art. It's not something you just go to a supermarket and buy off the shelf, right? It takes lots of effort. And in the time when corporate budgets are being extended, where the priorities are really tough economic times, where the competition is moving very fast, we need to make sure that there is a real investment in these technologies. And so companies will not do that unless they have some regulatory certainty and legal certainty that they're doing the right thing. So this is really the if you like, drivers behind our project. And this is what our paper is trying to demystify and explain. And you will see we're going to continue this work. We believe in this. We're going to look into some verticals, deep dives. And with that, I'm going to stop talking and really enjoy my team presenting. I'm introducing Eden Tape, who is our actually PETs, Privacy Enhancing Technologies Fellow, but works on other areas of emerging and transformative technologies like AI and other topics. And we've got our two directors, Natasha Gerlach, our director in Brussels, and Matthew Reisman, our director in US, who've been spearheading this project. So it will be a pleasure to hear from them. Thank you very much. And thanks to all, by the way, panelists as well for taking part. I really appreciate that.
Thank you, Bojana. Hello, everyone. My name is Eden Taib, and I'm the Privacy Enhancing Technologies and Emerging Technologies Fellow at CIPL. Thank you for joining our webinar today. As you will have seen, as part of our PETs project, last month, we published our white paper entitled Privacy Enhancing and Privacy Preserving Technologies, Understanding the Role of PETs and PPTs in the Digital Age. Thank you again to the business leaders, regulators, and PET experts for your contributions to this paper. You can find the paper on our website or by scanning the QR code on screen. I'll also like to mention, as Bojana says, we will be doing follow-on verticals to this paper and looking at PETs in AdTech, healthcare, and AI, for instance. Today, I will start us off by providing a brief overview of our paper and share our key findings and recommendations. PETs have been gaining attention for their ability to enable the use of data in the context of the digital economy whilst protecting the privacy of individuals. Now, these technologies are not a panacea, but they do provide real benefits across a range of use cases. At CIPL, we recognized very early on the tremendous potential of PETs in mitigating risks and supporting innovation. Through in-depth research and interviews with experts, businesses, and regulators, in our paper, we explore the different types of PETs and share our findings and recommendations as to how we can foster further development and implementation. In particular, our paper provides insights into the different types of PETs available. It demonstrates their application through various case studies and explores the extent to which PETs support data protection, principles and legal compliance, as well as innovation, and discusses obstacles to the development and adoption of PETs, and suggests ways to overcome these obstacles. I'm now sharing on screen some of our key findings. Firstly, from our research, we learned that organizations there are many motivations for organizations in developing and implementing PETs. Operationalizing core privacy principles. PETs support data use consistent with key privacy principles such as data anonymization and data minimization without affecting performance. Potential to aid compliance. Although the role of PETs in supporting legal compliance is unclear, as regulators issue more guidance, we are seeing that their potential to aid compliance is motivating adoption. Demonstrating accountability. PETs are key to demonstrating accountability, and with more data being processed than ever before, we are seeing an increasing need for this. Improving business processes and technologies. PETs can enable business practices and improve services and products by protecting privacy and security. Facilitating information sharing. PETs can enable cross-border data transfers and data sharing within different teams within an organization. Increasing security. For instance, homomorphic encryption can stop data leaks by making data unreadable to adversaries. We are seeing that there are different teams within an organization involved in the process of implementing PETs. For instance, privacy teams, researchers, engineers, security teams, and product teams are all involved in determining the utility and effective use of PETs. When choosing to develop and implement PETs, we are seeing that organizations consider the following: business considerations. What is the PET solving, and how will it affect operations and business goals? Cost and effort. What is the level of effort required to implement the PET, including cost? And is this in balance with their aims? Prioritization with competing initiatives. How does implementing the PET compare to other business initiatives and privacy initiatives? Privacy and security considerations. How is the PET mitigating security and legal risks? Here, guidance from regulators can be helpful. And finally, wider benefits. Are there any additional benefits to implementing PETs? We learned from organizations that they are also facing challenges during implementation and development. Integration with new technologies. PETs may be use case specific. Some PETs are more effective in certain situations than others. High technical requirements and cost. Ensuring appropriate security controls. Bringing in a new technology requires careful testing in order to ensure it does not introduce unintended security vulnerabilities. And we see that there are significant gaps in technical and policy understanding between PET creators and policy stakeholders. Mapping PET solutions to policy goals is proving to be a significant challenge. We learned from organizations that they are measuring the success of PETs in several ways. For instance, the performance metric of the product. This is seen through customer usage, demand, and feedback. Organizations assess whether the PET has functioned as intended. Is it enabling business practices whilst protecting privacy? Organizations review whether the PET has made processes easier for the engineering team. And finally, organizations assess the impact of PETs on legal postures and exposures. Is the PET mitigating privacy risks or enabling compliance? And finally, we explored the roadblocks to the adoption of PETs and learnt the following. Education and awareness. There is a lack of education as to the value of PETs. Customers and organizations need further education on the technology. Regulatory guidance. Regulators are acting at a slow pace. Many privacy laws do not consider PETs nor incentivize their use. Complexity and cost. PETs can require expertise to implement and can be expensive to deploy. Having said this, in our PETs webinar in September with practitioners, we noted that there are several more solutions out there now that are accessible for organizations, including SMEs, on how they can use PETs. Tension between utility and privacy. Some PETs mask potentially useful data, making it difficult to strike the balance between utility and privacy. And finally, reluctance for digital transformation. Organizations can be conservative in their approach to using the latest technologies. I will now share some of our recommendations as to how we can foster further development and implementation of PETs. Firstly, regulators and policymakers should do more to incentivize the pragmatic application of PETs. Organizations need clear guidance from regulators as to how they will interpret legal provisions bearing on the use of PETs. Policymakers should do more to really make sure that we are incentivizing organizations. Some regulators who are with us today, such as the UK ICO and Singapore IMDA, have taken proactive steps to incentivize adoption, such as through mechanisms of sandboxes and by issuing guidance. Secondly, PET developers and providers need to do more to educate on the technology. Potential deployers of PETs need to see tangible evidence of the value of PETs and how they can facilitate responsible data practices. Some PET providers who are with us today have been working hard to educate organizations and policymakers. Key stakeholders need to develop industry standards for PETs. Although some pets have some standards, others do not. By creating industry standards, we will codify best practices and foster trust in these technologies, and this will encourage implementation by providing a level of assurance. And finally, pets should be recognized as a demonstrable element of accountability. Pets mitigate risks and therefore are seen as compliance efforts and should be seen as showing effective accountability. I will now hand over to Matthew and Natasha, who will help facilitate an open discussion as to how we can foster further development and implementation of pets.
Ed, thank you so much for the great overview of our paper. And I also just want to thank you for your incredibly hard work over the past year. You've been a terrific asset to our team. And thank you, everyone, for making time to join us, and especially our speakers who are here at all hours of the day and night all around the world. We're honored to have you. And now what I'd like to do is turn to our speakers to share. Let's start with some reflections on what you've heard and whether you agree or disagree in any ways. We want to know. And so rather than take time to sort of have you say your name and your title and go down the line and then share your reflections, I'm going to call on each of you. I'll ask you to introduce yourself to our attendees and then share any reflections that you'd like to share right off the bat in response to the paper, having read it and heard Ed's summary of it. I'm going to start with Niels from IBM. I'm gonna start with our private sector guest first, and then give our government representatives the opportunity for the last word on this first question. So Niels, over to you.
Thank you very much, Matthew, and thank you for having me here today. My name is Niels Hullen. I'm the Program Director for Global AI and Privacy Policy in IBM's Office of Privacy and Responsible Technology, formerly known as Chief Privacy Office. So we just rebranded to reflect the development that we are also responsible for AI and data. And that is also my connections to pets, obviously. I think it's an excellent paper which we have here on the table, and thank you very much to all who contributed here, because I think it serves different needs of different target groups alike. Yeah, it's a great entry point for beginners to learn about the subject. If you have dealt with pets before, it provides.
Niels, just a comment. I at least can't see you. Is your camera on? Can you double check, please?
Yes, my camera is on.
Oh.
Yeah, we don't see you. You're loud and clear, though. So.
Yeah, we hear you very well. We just can't see you, just as a comment.
Looks like you're coming on.
There you are.
Now. There you are.
I switched it off and on again, but it was on. I hope you can see me now.
All good. All good.
Must have been some pet.
The most important thing is that you can hear me loud and clear. Yeah, I think it's a great starting point for beginners, but also for intermediates. Yeah, because it provides you with a structure to dive deeper into understand the different categories and purposes, the benefits, the limitations, but also the solutions to overcome existing obstacles. And if you are a pet pro, you can find helpful overviews on the ongoing initiatives and publications of regulators and other institutions to look deeper into the secondary literature, to dive deeper into specific use cases, and to learn about emerging pets and how to combine them in a meaningful way. And personally, I'm interested in the policy side and in highlighting further best practices for lawmakers and regulators. And from a developer's perspective, IBM is also developing, of course, pets. I'm interested in the use of pets specifically in the development and adoption of AI in a responsible way.
Niels, thank you so much. And that's the first time I've heard the phrase pets pros. I think we're going to use it again. Love it. I think everybody who's attending now is on their way, if not already, a pets pro. Our next speaker, I want to go to Grady. Would love your perspectives from MasterCard. Yeah.
Thanks. Yes, my name is Grady, and I am the Assistant General Counsel for the Privacy and Data Protection team that supports the Data and Services Business Unit at MasterCard. And that's where PETS comes into play for me. So we provide a lot of services to players across the financial payments ecosystem that leverage data right? And we want to do that in a way that protects the privacy of consumers and embeds privacy by design. I truly believe that to maximize the potential of something like pets or other technologies that are emerging like AI, companies need a consistent and principled approach that's based on fairness, transparency, and consumer privacy. And very fortunate to work at a company like MasterCard that's been doing that for some time. But no one does this alone. And what thrills me in particular about a white paper like this is how it brings together so many different perspectives on an area that's highly technical, and yet in order to see successful adoption, must be understood by a broader universe of decision makers than just the pets pros, right? Just the highly specialized practitioners. I think that this white paper takes an important step alongside other guidance and thought leadership and forums taking place around the world that helps demystify, in particular, what I see as two key principles of pets, right? One is that pets themselves are a diverse set of capabilities, and no pet is a single bullet. And two, you must understand your objective if you want to use them effectively. I think that to new initiates on the topic of pets, they may think of them as kind of a bland generalization, something that's privacy enhancing. They don't know exactly what they do, and they may be reductive in their heads to think maybe it just does anonymization or something very specific like that. But in fact, I think they have a variety of applications. And being introduced to the topic through a white paper like this, I think contributes to the common body of knowledge on what pets can achieve, and that paves a pathway to wider adoption.
Grady, I wrote down 3 types of diversity: perspectives, objectives, and technologies. So that's a great takeaway for us. Rena, I'd like to bring you in as a true pet specialist. We have lots of pet specialists, but especially we're appreciative of the perspectives duality completed the discussion.
Thanks. So my name is Rena Shainsky. I am a co-founder and chairwoman of Duality Technologies, and we provide solutions based on pets. We have a platform that productizes a pretty deep technology like homomorphic encryption, federated learning, trusted execution environments, etc. They all appear in the white paper, and I wanted to make a few comments. I think all of us, I mean, the market, the regulators, the vendors, are facing a really most difficult challenge because the technology is racing forward, data is accumulating exponentially, and now not enough that we have all this happening. Now we have even a big step function, which is like Gen AI and LLMs. And all this needs to be regulated vis-a-vis privacy. And I think it puts enormous challenges to everybody. And that's why there is a lot of confusion, basically, in the market. A lot needs to be clarified and explained. And this white paper, I think, plays a very important role in giving a pretty broad overview on the current state of pets and which specific use cases they actually address. And it gives a good overview for anybody that wants to understand the current state of the market, even though everything is moving forward very, very quickly, as we know. So, and we had also this privilege of collaborating with the regulators, with ICO, with IMDA, and also with MasterCard in actually demonstrating and putting use cases out there, and really promoting the very fundamental, basically, concepts of privacy-enhancing technologies for the last 7 years. So it's actually quite a lot of experience.
Rena, thank you so much. Just to let you know, we hear you loud and clear. I don't think we're able to see you.
No,
not yet. But we heard your remarks well. You spoke about use cases. That's a great moment. There you are. Great to see you, Rena.
Sorry.
No problem.
Yeah.
Every one of our panelists is from organizations that have amazing case studies of how pets are really being put to work in the real world, and have been generous in sharing those stories that appear, many of them, in the white paper. So commend that to everyone. Speaking of use cases, our next speaker has one that I've used this morning using my iPhone. So over to you, Eric, from Apple.
Great, thank you. I guess I'll start off by asking, can you see me?
We can. It's a little granular for me, but we do see it. There you are.
All right. Hopefully it'll pop in. All right. So thank you, and thank you, Boyan, and the rest of CIPL for this opportunity, and really for everybody who's attending and joining and showing interest in this. I'm Eric Neunschwander, Apple's Director of User Privacy and Child Safety. And for privacy, that means that we're responsible for privacy by design across Apple's products and services. Now, to us, privacy is a fundamental human right, and so chief in privacy by design is data minimization. And that has a great alignment with today's topic because, as CIPL paper shows, pets are an important tool that supports data minimization. I really do appreciate CIPL's research here and the decision to publish on the topic of technologies that help privacy, because I think it's very important to continue the education of people about pets. In particular, I really thought the paper covered all the bases. I mean, what pets are, what they can do, but also how they fit into organizations and the regulatory aspects. And you mentioned Face ID. That was one of the case studies in the paper. And I think the case studies in general are an important step to really show people that these are deployed in the field, that they are working, that pets are real and doing real work in features that companies are using on a daily basis and customers are. And I think that's great. If I wish for just a little bit more in the paper, it would be not to forget that pets have been with us a long time. It talks about the origin of the term, but really anything that transforms data in a way that decreases privacy risk, to my view, enhances privacy. And so as technologists, particularly at the larger firms, we can focus on some of the newest and most complex technologies, and they're really great to unlock some new benefits for users. But I worry sometimes the focus on that also scares off firms that don't have the resources or the risk appetite to invest in some of the most state-of-the-art approaches. And there are really simple things like associating data with rotating random identifiers that can minimize data collection and its impact. It's privacy enhancing, but not in any way really complicated or expensive. And increasingly, even with AI inference, companies can design systems that can do computation at the edge, locally on the user's device. And then in that case, data collection might not be required at all. So as all of us continue to push the frontiers of data processing, I think we should also keep in mind approaches which, while much less flashy, might be powerful in their own right for many use cases.
It's a really well taken point, Eric. And look, we did focus a lot of our research in this paper on the frontier, I think is sort of a deliberate effort to demystify, but you make a really valuable point that that's not the end all and be all of privacy technology. And there's a lot that's out there in the world ready to be used. We'll also say that some of our panelists are doing amazing work on bringing the frontier closer to those with either less financial resources or in-house know-how. And we are grateful for that. I'd love to turn over next to Paul at the ICO to provide some initial regulatory response, and then we'll close out this first part with Adeline. Over to you, Paul.
Thank you very much, Matthew. Hello, everyone. My name is Paul Comerford. I'm with the Information Commissioner's Office in the UK. We are the data protection regulator. I sit in the anonymisation and encryption team at the ICO, and we are responsible for the guidance on pets and also the upcoming guidance on anonymisation. So I'd like to say that this paper presents a really excellent holistic worldwide review of pets activity, and it's great to see all the various things going on from regulators and industry. There was a very comprehensive set of case studies, which was great to see, and it really highlights the flexibility of the pets, both in isolation and when combined. I think the recommendations, I would agree with the recommendations made, particularly around things like cross-border data transfers, for example, regulatory incentives. As you know, we've released our own pets guidance, but I think it would be welcome from other data protection authorities that haven't released any guidance yet. I think that would be useful. And also, the recommendation on standards, I think that's a really important one as well. We are involved with some of those standard setting initiatives around PETs, so I think that's going to be an important part for adoption. So yeah, excellent paper, and yeah, I agree with everything else that's been said so far. So that's it from me.
Paul, thank you so much. Again, no pressure, but if you care to turn your camera on when we come to you again, please feel free to do so. Before we go to Adeline, I just want to thank you personally and the ICO and IMDA for being really true world leaders among regulatory bodies in paving the way forward for PETs adoption. Mm-hmm. So just taking a moment to thank you. And it's a special honor to have you with us today for that reason. Adeline, you definitely win the award for commitment for being with us tonight. Oh, Boyana, can you? Oh, no. Okay, spur his hand. No worries. Adeline, over to you. With special thanks for being with us at a truly late or early hour, depending on how we want to count it.
Yeah, thanks, Matthew. Can you hear me well?
Yes.
Yeah, okay, yeah. So Adeline from the Personal Data Protection Commission in Singapore. Yeah, and thanks for inviting us to speak at this event today. I think I'd like to echo what the rest of the speakers have shared. I think the paper is an excellent one. It's really laid out what PETs are for beginners, and as well as outlining a lot of the key benefits of each PET technology. I particularly like the fact that the paper has also illustrated a number of the case studies to showcase how PETs are being used, has also shed light on some of the business considerations, the challenges, and the roadblocks. And I do agree in general that there's a lack of awareness of what PET is about in the ecosystem. So it really helps if we come together in such platforms to kind of share and learn from each other. What some of these considerations are and how we can really maximize the potential of this technology. I think one of the important areas in which, as a regulator, we see PETs, the benefits of PETs is really how it can support organizations in demonstrating accountability. I think that's really a core principle in many of our data protection laws and regulations, and definitely for Singapore's Personal Data Protection Act. And we do recognize that potential for PETs to support the use and sharing of data in a trusted and accountable manner that's consistent with our regulations. But I'm also mindful, I think from the paper itself, there was quite a lot of points that were raised around barriers to industry adoption. So some of these things, we have to tackle them as well, including complexity in the implementation amongst organizations. I think many of you have mentioned that different PETs help in different ways and have to be used in whether it's by itself or combination of others. There's also the consideration of resource constraints, I think especially with small, medium enterprises, and a recognition of whether there is actually sufficient resources today to actually support the adoption of PETs. I think the last reflection I have is probably I noted that in the paper there's this huge call for regulators and policymakers to issue more regulatory guidance on PETs, and I wanted to thank CIPL for also calling out Singapore as one of the regulators who have kind of tackled this together with IMDA kickstarting the PET sandbox in 2022 to really kind of bring the ecosystem together by matching case owners with PET solution providers. I do want to also flag out that we are still learning from that process, I think, of running through the sandboxes because of the complexity of the cases involved, the ability to work with different stakeholders. And there's still quite a lot of things we are learning from actually working with each and every one of the PET ecosystem players in this sandbox. Yeah, I think that's probably something for us to consider as well. Yeah.
Well, first of all, Adeline, thank you so much for those reflections. And I think you talk about learning from sandboxes, at least as we conceive it, that's what they're all about. So it sounds like in one way they're working well. Just a technical aside, I don't know if you had your camera on. I'm wondering if we're running into a Teams issue where if there's a certain number of people whose video is on, then other people can't come in on video. That's why Malachi put in the chat there to try maybe if folks are not speaking to have cameras off and see if that allows others in. We're not sure if that's what's going on, but we apologize for the technical difficulty. Let's go to the next set of questions. Yeah.
May I interrupt for a second? My apologies. Hi, I'm Natasha. And Bojana introduced me earlier. I'm the director for data and privacy policy in Brussels, in CIPL's Brussels office. Two things. I just wanted to let you all know to please comment if you have questions on chats, and we already had a few and I answered them, but if there are any questions or comments, please do post them in the chat and I'll make sure they will get into the discussion here. And second, just as an FYI, because Adeline talked about sandboxes so much, we do have currently another project running where we are looking at the benefits of sandboxes and the learning that we can derive from sandboxes that have been around for a while. So please, everybody stay tuned for CIPL's work on that as well. And so with that, I'll go back to moderating the chat.
Well, Natasha, thank you for jumping in. And actually, I did want to give anybody on the CIPL team, Bojana or you or Eden, any other opportunity to respond to what the speakers had said verbally before we move on. If not,
well, I mean, personally, from my side, having also worked extensively on the paper, I'm gratified to have all these positive comments and all the remarks that you made. You know, we're taking them back, and as we mentioned, we are working on follow-on papers, verticals on PETs in specific use cases. And so, you know, the case studies, we are happy that everybody agrees that those are really useful to create a tangible research result. You know, we will take that to heart and make sure that we have those also represented in the verticals, which will be on, for instance, Niels mentioned that at the beginning, on AI and PETs, will be an ed tech and potentially also age verification, age assurance, and then for healthcare research. So those are the topics that we are currently thinking about. But we are very, you know, we're grateful, as I said, for the input and the accolades we got, and we will continue our work in this area.
Natasha, thank you so much. I'm going to go to our next question. This one is for our private sector speakers. So Eden outlined in sort of the overview of the paper the importance of incentivizing adoption and development. And I wondered if I could ask, let's start with Niels again, and then we'll move down the line of our private sector guests. Let's dig into that a little deeper. What can incentivization look like from your perspective in industry to meaningfully incentivize development and adoption more fully?
Thank you. First of all, can you see me?
Yes.
Perfect.
We can see you. Thanks so much.
And you can hear me. That is great. I think there are three key elements to foster the development and the adoption of PETs. First, privacy laws should provide legal certainty around PETs and incentivize the use of PETs. Second, and Bojana mentioned that at the beginning, regulatory guidance is necessary to educate on benefits and limitations, but also to clarify the regulator's view. Where does it make really sense from a regulator's perspective to use PETs? What are the use cases? And every regulator also in Europe has a little bit different views. So it's highly appreciated if we hear from regulators to gain a little bit more insights into their thinking. And third, cooperations between technology providers and standardization efforts driven by industry players to reduce costs and to provide PETs as a service, as a product, which can be easily integrated into compliance programs. That are three core or key elements. And let me just touch upon the first point I mentioned, the legal certainty. The European General Data Protection Regulation mentions pseudonymization 14 times in the legal text. and policymakers provided a good amount of clarifications and incentives around pseudonymizations, for example, when using data for new compatible purposes, or when it comes to fines, if you have implemented technical and organizational measures, including pseudonymization, that has to be taken into consideration by regulators, and that can reduce the fines. And the European legislator also clarified that pseudonymization and use of pseudonymized personal information is possible within the same entity controlling the data. That is great. But the legislator did not provide clarity on the requirements around anonymization properly. And many EU regulators and courts follow a very strict interpretation, which makes it virtually impossible to anonymize data as long as any other person could, in theory, identify the respective individual being subject to the anonymization effort. And that is also mentioned in the PETs paper. A recent decision of the European General Court followed a more practical interpretation of the concept of anonymization, but to gain really legal certainty around the concept of anonymization, which applies in Europe under the GDPR, we need a final decision of the European Court of Justice. And that will leave us with more than 6 years of unclarity and uncertainty after the GDPR entered into force in May 2018. And just to be fair, there are many, many privacy laws which do not even mention PETs, anonymization, de-identification, or pseudonymization at all. But this debate in Europe has and had a clear impact on the uptake of anonymization techniques. And for example, the question if homomorphic encryption is suitable to compute on anonymized data, or if privacy laws do apply in the end.
I want to give, first, before we go to our other speakers, I think you're speaking to the heart of a lot of issues CIPL cares deeply about. I was going to ask Natasha Boyana if there's anything you want to respond there. If not, Rena, your point's well taken. Again, we're trying to work through the technical issues together. We can try just having speakers only, please, have their cameras on. We'll give it another shot. So, Natasha Boyana, any quick responses on the GDPR point before we move on to our next speaker? Or even a plug for events coming up?
Well, here Boyana did post in the chat that Niels made a great point on. Do you want to? I mean, I don't need to be the voice of the computer. Boyana, do speak for yourself.
No. Honestly, I mean, this is a great example. You know, sometimes this is the value of meetings like this, right? Where we actually are able to bring these case studies as well as in the paper, right? To say to the regulators, here is where we really need your help. Okay, people are not going to invest in anonymizing data if all data is always personal data. So we need to protect and say, actually, by doing this, we will accept that you have done risk-based proportionate response to anonymized data. FTC has got a very good approach, dare I say, so we need to have this sort of FTC level of anonymization more globally. But this is exactly the kind of scenario where good regulatory guidance and accepting that nothing is 100% perfect, but you know what? Perfection is the enemy of good. And that's why I love this example. So thank you, Niels, for bringing this.
Boyana, thanks so much. Rena, we will go to you next. I don't know if you have any additional thoughts to add on this question of incentivizing development and adoption.
Yes. Can you see me, by the way?
Yes, I can see you.
Yeah.
We're making it work.
Okay. Yeah, and I just wanted to reinforce this regulatory clarity. I think it's probably number one priority, because organizations, in order to implement PETs to address regulation, it requires investment, and they need to know if by implementing PETs for the type of use cases they need, they actually addressing the requirements of the regulators. And that's why it's so important, this sandboxes or case study examples by the regulators to, it's clear that it cannot be a blanket kind of approval or recommendation, but there are categories of use cases. And I just want to give an example. The the use case that was published recently by IMDA, the sandbox, doing with MasterCard of a cross-border collaboration using homomorphic encryption. The idea there is really around being addressing the anti-money laundering kind of requirements, but being able for intra-company inquiries to be executed while protecting privacy. So this was one example. And then on the ICO website, we have a case study also using pretty much the same technology, which is protecting the privacy of the inquiry. So the protecting the query with homomorphic encryption, but not in a cross-border situation, but more within let's say UK. There are inquirers and there are responders, and there is a protection of privacy of the subject of investigation. So this covers, by the way, where two types of regulations are meeting. One is the anti-fin crime, anti-money laundering versus data privacy. And in one case, it's cross-border. In the other case, it's within a given country. But the importance here is that these examples analyze the legal aspect and also what's being protected and how PET helps. And that, I think, now can help many other organizations that have a similar challenge, and they can now use this example. So I think, and this is just one example of using a particular kind of setting, and there are many others. So I would definitely emphasize that regulatory clarity is extremely important. We realize it's not trivial at all because there are many cases and many PETs, but kind of clustering them is very, very helpful.
Rena, thank you. You bring to mind a phrase that our colleague Mark Smith, I think, coined, which is orchestrating a symphony. That's something that often has to happen across regulatory domains as well, as you pointed out. You mentioned MasterCard. Maybe that's a great transition over to you, Grady. You can just either speak about the example given or anything else you'd like on this topic of incentivization.
Yeah, thank you. I think I'll speak to the topic of regulatory certainty since that's a theme right now first, and then I've got a few other comments around adopting or incentives to bring more widespread adoption. On regulatory certainty, I wholeheartedly agree that that is a helpful element, especially for the decision makers who need to invest in these technologies. They want to know that their investment's going to pay off. They want to know what it's going to get them. And having certainty around how regulators view your use of privacy-enhancing technologies is definitely a key factor there. In particular, on one topic, and this is a very basic one that I don't think requires rethinking at a deep level how we address this, but the lawful basis for processing personal data and having additional guidance and clarity from regulators on the processing of personal data that is required in order to get to the end state of having implemented privacy-enhancing technologies. You always start from a world of personal data. You apply the technology on top, and sometimes that requires a series of steps of data processing activities in order to get to the desired result. Now, I think it can be very straightforward in some circumstances. An organization may have a legitimate interest to do so, but also keep in mind that not all privacy jurisdictions around the world have legitimate interest as a lawful basis of processing. Sometimes it's consent only, and where an organization may not have a direct consumer relationship, that can actually be a disincentive to adopting privacy-enhancing technologies. So guidance as well as awareness on the regulatory side that organizations are thinking about that and trying to get from point A to point B, and what do I need to do to be compliant in the interim. In terms of other things that I think we can do to incentivize greater development and adoption, one, recognize that PET's adoption will follow the overall life cycle of technology adoption. You're going to have innovators, they will be followed by early adopters, and you're going to have early majority, late majority, so on and so forth. And so when you're speaking to different audiences or potential users of PETs, understand who they are, where they might fall in that life cycle, right? Because the nature of your relationship or interaction with them may differ depending on where they are in that journey. Second, I think that we actually need greater training and investment in developing a workforce that can do this. Right now, I think we've got a very eclectic group of people who are very interested and motivated in this topic, but we need more formalized training, and that may come in the form of partnerships between universities, governments, and corporations to build programs that train new graduates on privacy-enhancing technologies and how to deploy those effectively. Beyond that, I think we need to keep this conversation as we are today, expanding beyond the world of just the specialists themselves. We need to bring in people who are not normally in that circle, help them get a basic understanding of what these are and what they can do. And it always helps in those conversations to have specific practical examples. Rather than talking about the abstract technology itself and all the things it can do, talk to organizations or individuals about what it can do for them. What problem can it solve for them? What can it do in the context that makes sense? So the more we can continue to evangelize in that way, I think we will encourage better both development and adoption.
This is great. Thanks so much, Grady. And on the point of lawful basis for processing, another topic that is just core to an areas of focus for CIPL. We couldn't agree more on that importance. I think, Bojana, were you raising a question?
We have a couple of questions in the chat. Well, one specific question, one comment. And I think we have a quite technical question. And Rina, I don't know if I may punt this to you, because it's sort of echoing a discussion I think we had on the panel we shared at the IPP Congress here in Brussels in November. It goes to differential privacy, specifically within data clean rooms. It's quite technical questions, so apologies for everybody more interested in the policy discussion. But the question is how well positioned data clean rooms are in becoming a viable practice within PETs in the context of this. And so maybe this is something that I can punt to you for a quick turnaround. And then we have a question from Bojana as well. And I have a comment that I am going to also talk to.
So I will not go to, will not dive too deep into that, but the fundamental question that anybody implementing PETs that needs to ask who they are trusting or from whom they are trying to actually to protect. So in the case of clean rooms, very often you do trust the provider, the operator of the clean room, that they can actually see the data that comes in and operate on that data. And then the differential privacy is you need, again, the question needs to come whether the input data that comes to the clean room has been protected by differential privacy, or the result is being protected. So without going too far, there are various levels, and that maybe is important to understand, or kind of fundamentally, the trust also is going through redefinition, so it's not binary anymore. And like, it's not like if you trust, you give everything you have, all your data, and if you don't trust, you just don't do anything. PETs actually make it possible to have, in a way, like really a spectrum of trust levels. And then depending to how you want to protect and from whom, you use the relevant PET for analyzing the data. And also, do you trust the third party in the middle who operates the service for you or not? And sometimes there are PETs that can even protect from that third party. So, today, without PETs, if you sign enough legal agreements and you trust the party in the middle, you can just pretty much work the way you work today if you have enough consent and so on. With PETs, you can avoid some of it because some of the analysis can be done without any of the parties being exposed to the data that is protected. So we are talking about a spectrum of means to protect data when you process it. So if the answer was not completely addressing, you know, the exact scenario, welcome, very happy to talk after.
Thanks so much for this, Rina, for this expert response. And Eric, not to put you on the spot, but as you know, one of the engineers on here, anything to add, anything to weigh in on there from your end as well?
I agree with what Rina said about it being a spectrum. Certainly, I think we try, or the best designed systems minimize the amount of trust or the imposition in particular on the user to require to trust other entities to be as protective of their data as they might be themselves. But it is a continuum, and certainly when viewed from a legal perspective, I think that there are certain things, we're talking here a little bit about regulators, where the requirements go up or down. From a technologist standpoint, I think it's best when you're reducing the number of parties or entities that require any amount of trust as much as possible.
Thank you so much for this,
Great.
Eric. And then we have a question. Sorry? Okay, sorry, that was an echo. We have a question from Bojana to all the panelists on, you know, leaving from Niels's example as well. What are other key case studies where PETs or PPTs can be helpful in addition to anonymization or the legal basis discussion that Grady brought forth? Are there any other examples that you can think of that we should be covering, for instance?
I can certainly highlight a few, Natasha, and some of them
Please.
I think are compliance related and some aren't. Some are just for, you know, better use of data. So the first one was mentioned by Rina, the Singapore sandbox exercise that MasterCard was fortunate to participate in, leveraged homomorphic encryption in order to enable cross-border sharing of financial crime data, right? Now, the idea there is that you only expose what the requester is asking for and not your entire database all at once, right? And so that's a useful example of where you can apply the technology to facilitate a regulatorily useful outcome without oversharing or overexposing, right? But it does constitute a sharing of data at the end of the day. It's not anonymization. It's not protecting the identities of everyone. You're still facilitating that exchange, but in a more secure way. Another one is how people use synthetic data. Some people may be using synthetic data to build an anonymized data set. On the other hand, synthetic data can be used for a number of other purposes. You may have an entity that is attempting to build fraud models, for example, and doesn't have a wealth of data at its own disposal. And in order to build really effective models, they need more volume of data, and synthetic data can help them along that journey. Bias detection, right? A lot of entities right now using AI building models are tackling the challenge of bias detection. And one way to do that is to take your data set, build a model, and then evaluate the bias that demonstrates or manifests itself in the model. Another way is then to take it back to the data set itself, right? And understand how bias is exhibited within the data that you have. And synthetic data potentially could be used as a tool to reduce or mitigate the impact of bias in the underlying data set itself.
Thank you. That was really fascinating. I hadn't thought of that. Niels, you have something to?
Yeah, maybe I can just add to the AI angle on that here. Homomorphic encryption, would be also something which allows you to train AI models on encrypted data, which is obviously very helpful, and as well synthetic data, which would allow you to emulate specifically sensitive data, which is of course hard to reuse for training purposes, and to train your AI models on synthetic data without coming into the conflicts with specifically protected sensitive data.
Yeah, this is really interesting. And you know, frankly, I've been always looking at the synthetic data of something in the context of pharmaceutical or medical research, health research. But I loved Grady's wider examples as well. So definitely something to think about for our verticals. And I think your example, Neil, is definitely for our health data research example and PETs. Matthew, I think I'm going back to you.
Thank you so much, Natasha, and to our speakers for jumping in with those examples. I now want to turn back to our guests from the ICO and IMDA to talk a bit more about expectations of regulatory bodies in terms of organizations using PETs. Adeline, let's start with you this time, and then we'll go to Paul.
Thanks, Matthew. Can you see me this time? Okay. Yeah, so as a regulator, I think specifically, at least for data protection, the Personal Data Protection Act in Singapore, we work on a principles-based approach, and we also are we take quite a neutral stance with regards to the type of technologies that companies use. So I think as long as the use of PETs allowed the organizations to demonstrate accountability, allowed them to comply with the regulations and adhere to general data protection principles, such as I think it was mentioned data minimization. I think that's where we would like to encourage companies to consider the adoption of PETs. However, I guess we are very much also very aware that beyond data protection considerations, organizations will have also other business considerations outside of regulatory considerations, whether PETs are cost effective, and whether they even have the digital infrastructure to support the usage of PETs. So I think as a regulator, we can't really intervene, I guess, with the kind of pros and cons decision making that companies have to take upon themselves. They have to kind of like look into the holistic view of their data policies and practices, and while they are being open to incorporating the use of PETs meaningfully in their operations, they would also have to sort of look at the expectations of the particular jurisdiction in which I think they are implementing their PET solution. And as mentioned before, I think at least for Singapore, the PDPC and IMD are very open to working with industry on impactful use cases through the PET sandbox that we have kickstarted way back in 2022. Yeah, hope that helps.
That's very helpful. Maybe a casual way of putting it is an effort by PDPC to reduce the fear factor, if you will, on trying this out, and then to have dialogue with you on that. Paul, how does this resonate, and do you have any different perspectives on it? Yeah.
Thanks, Matthew. Can everyone see me okay? Yeah, excellent. Yeah, I think I would just like to agree with what Adeline just said around that. I think obviously we operate under different laws to Singapore, but I think looking at PETs from a compliance standpoint, data protection by design and default is obviously one of the key aspects to compliance, and I think PETs are one of the ways that can be achieved. Obviously, it depends on the risks and the nature of the processing that's taking place.
Okay, I will be with you as soon as I can.
Sorry, I think we may have, make sure if you're not speaking, if you're on mute. Thanks so much.
Yeah, so I mean, basically, it depends on the risks, but obviously, PETs can help with data minimization. In some cases, they can help anonymize data depending on the circumstances of the processing. So one of the reasons we developed our PETs guidance was the changing trends in personal data processing and the rising risks to individuals, and also the maturity of PETs as well. Several years ago, PETs weren't really ready for adoption, but over the last 5 or so years, we've seen great advances in that regard, and most pets now are suitable for adoption. So yeah, I think that's about it. I don't think I've got anything else to add.
I will intervene before going to our next prepared question with one point of curiosity. Just can't hesitate or can't bear not to ask. Curious if you are finding, your two agencies have been such leaders globally. Are there opportunities where you're finding dialogue with other regulators who are curious about pets and seeking to learn from your experience? Or is there more that we all collectively need to do to help with that? Maybe the answer is yes and yes. Curious if there's any insights to share there.
I mean, from the ICO's perspective, we do talk to other regulators, both within the EU and elsewhere. For example, we're part of the G7 nations group developing a synthetic data case study, which we're hoping to publish very soon, which is a healthcare case study. So yeah, we do talk to other regulators regularly on these issues, and we will welcome guidance from other data protection authorities as well.
Adeline, any additional thoughts on that?
I agree with Paul. I think we've always been open to engaging with the regulators, and we are part of a number of international networks as well. And I think the idea of perhaps I guess regulators in a way are also differ in their maturity in terms of understanding how technologies can be used to comply with their respective laws and regulations. And I think it's also quite dependent on what sort of case studies or use cases they come across and they think would be impactful in their respective ecosystems. I do think that regular exchanges help, at least to kind of level up the understanding that each regulator has of what industry is evolving and moving towards. So I think I mean CIPL's paper is a helpful piece of work, I think, to put everyone on the same page as well.
Thank you so
Matthew,
much.
do we have time for a couple of questions?
Please, let's do it.
So I
Jump
have
in.
one that's rather technical, and Paul, actually I might want to ask you if you would like to give some input, because I believe you covered this in your guidance as well, effectively asking about whether there's research into the issue of when you are implementing these certain control mechanisms to improve privacy or safety, security, etc., such as PETs, that you are inadvertently introducing other risks or issues with that. And I believe there was a section in your PETs guidance where you talked about this and the steps that organizations have to take. Can you maybe give us a couple of comments on this?
Sure, Natasha. Yes, I think obviously PETs are very complex technologies, and not every organization will have the expertise in-house, and that poses a risk, particularly if mistakes are made in implementation. So it's really important, if you haven't got the expertise in-house, to seek out appropriate expertise, for example, a PETs provider that has that expertise and can bring that into the organization. So yeah, and also adherence to things like standards can help in that regard as well.
Thanks so much, Paul. And then we have a question from Sam, who is asking whether any of the panelists have, in fact, any examples of privacy laws that are currently effectively incentivizing pet adoption, and if so, if you can provide any. I don't know, Paul, if you want to start, since you're unmute already, but we'll do it to the tablet.
Yeah, I mean, looking at the GDPR, UK, EU GDPR, PETs is not, as a term, is not actually referenced in that legislation. So the way we look at PETs is through data protection by design and default. building data protection compliance in from the design stage rather than trying to bolt it on later on. It can provide, some PETs can provide anonymization, but that's not really, the way we look at PETs is not really data protection avoidance, it's more of data protection compliance. So I think from that perspective, PETs are a great way of minimizing personal data, you know, as Adeline said earlier as well. And also, although it's not explicitly mentioned, international data transfers, I think, is another area where PETs could be utilized, but at the moment there isn't a lot of there's not a lot of guidance on that from regulators across worldwide, I would say. But yeah, I think those are the areas that can help.
Thank you, Paul. Any comments from any other panelists on this point?
Yeah, Natasha,
yes.
I mentioned that in the beginning. I would love to explore deeper best practices, yeah, because we have to strike a balance. We don't want to mention a specific PET, a specific technology in a legal text. So I completely agree with Paul. We are talking here about privacy by design, about state of the art, about standards which are referred to in legal text and privacy laws. I can think of the US laws mentioning and referring to de-identification, which is a different concept to what we know here in Europe when we talk about anonymization. And also, the AI Act has specific references to technological solutions, state of the arts, and a lot of standards. So I think there's also a lot of potential there when we talk here about privacy enhancing technology or responsibility enhancing technology in a broader context in the end.
Thank you, Nils. I think both of you made excellent points about having to understand the law in the current, in the present, and interpreting it in the present context. And Paul gave a couple of good examples. I think Nils, yours were really important as well. And so this also speaks to the importance of having technology neutral laws. So we cannot write very specific tools in there that do not allow us for this perhaps more expensive or more up-to-date interpretation of the law as technology continues to evolve. Matthew, I might hand back to you. I have another question that popped up just now, but perhaps we go to the next.
Sure, absolutely. I'm going to go back to I'll start with our private sector guests on this one, but again, welcome our regulators to jump in if you wish as well, which is back to this point on education. I think we've talked about education in a number of directions. One is industry speaking with policymakers and folks in government, but also within organizations, right? There's a lot of industry teaching each other, practitioners teaching, business leaders. And I kind of want to throw open this question of education. What are the best approaches to educating policy regulators and fellow travelers in organizations about PETs? And Grady, you've got your camera on. I'm going to turn to you first.
Sounds good. My favorite way of educating everyone is participation in these types of sandboxes or joint exercises where you test a PET capability in the context of a specific problem. I think it's extremely beneficial for everyone involved. And I think the reason for that is because exercises like that extract everyone from this realm of the abstract. What does the technology do? We all start sounding a little bit like an echo chamber. And instead, it places you into a real context, right? And you simulate the solving of a real problem using, if appropriate, simulated or synthetic data. And I think that joint exercise teases out potential points of tension between different stakeholders, right? Because we do have different interests, regulators and industry and others, right? It also helps to illustrate the objectives that each of the participants has, and thereby can expose unknown synergies, right? And can really start to inform the development of more practical hands-on guidance. right? We all appreciate any guidance from regulators that we can get on this topic, but guidance that is informed based on a hands-on, real-life experience with the pet is just as useful, if not more, right? It's almost like the way you think about understanding case law versus statutory law, right? Understanding how the rules have been applied in a specific context can really be helpful to an organization and can serve as an example and say, you know what, we just observed that sandbox exercise. I think we can do something similar, right? It provides an example for emulation and thereby promotes both education and adoption.
Even as a non-lawyer, I really appreciate that case law versus statutory law point. It resonates. Rena, I wonder if we could turn to you if you have any thoughts to add to Grady's.
I think the question is whether there is interest in specific pets or there is a specific use case that an organization tries to address and they want to know how to address it and while protecting their data. Because if it's specific pets, I think there are quite a lot of quite many resources online on each and every pet that, you know, if you talk homomorphic encryption, there are webinars and federated learning and trusted execution environment. All of those have, you know, reach a number of resources. If there is a specific use case, I think that's where it becomes more complex and there is a need to see how a use case maps into maybe combination of pets. I think you also mentioned it in your white paper that often a problem is addressed not by a single pet, but actually by combining, and there are some very interesting and real world cases of combining, for example, federated learning with trusted execution environment or with a differential privacy and so on. So I believe that's where one would need to actually look for similar use cases, either through regulator examples or, you know, various resources and maybe vendors that provide solutions which combine pets.
That's really helpful, Rena, and I think points to sort of context-specific education on the problem one is trying to solve very much to try and find the right solution. I want to give maybe Niels, do you have any additional points on that one, on this point of education?
Yeah, just maybe a general observation. Entering into an open dialogue, yeah, as we do it here today, is the starting point. And my observation is that sometimes we are all a little bit afraid. And my advice is don't be afraid. Yeah, we industry stakeholders are sometimes afraid to present solutions to regulators which are not perfect yet, and we are afraid of a negative kind of verdict or reaction, which would have an impact, right? Yeah, so the regulator says upfront, okay, we don't think that this will suffice or that this has really teeth. It would, of course, have a negative impact also to the development, but we shouldn't be afraid. And also from an industry perspective, we have to, and I completely agree with you, Grady, we have to learn to present complex matters in a clear and digestible way. And we did that around homomorphic encryption, for example, yeah, where we also have use cases laid all out, but also toolkits, sample code, demonstrations in terms of simulations, webinars, and that costs money, effort, but we have to do that from an industry perspective. Regulators should not be afraid of the levels of technical details and expertise needed. And I know that not all regulators have the sufficient resources to look also into that area beside their day-to-day work. And lastly, I think lawmakers should not be afraid of exploring these innovative ways to make regulations fit for the data reality in which we are living, where data, cloud, and AI are fundamental technologies. And again, having that open dialogue is a starting point, and then I think education will definitely follow.
Thanks so much, Niels. Again, another theme I hope comes out is reducing the fear, not being afraid. It's a great point. Eric, anything to add before we give our chance to our regulators to respond to any points that are made? Yeah.
Sure. I really do think education is a challenge. I mean, both technology generally, and certainly when we're talking about pets advancement, moves at a rapid pace. And so I really welcome policymakers and regulators increasing in-house technical advisory staff. I mean, for all of us, even on the industry side, it takes time and effort to come up to speed with what can be done to enhance privacy, what the threats are, what technologies we can do to mitigate the threats. And I think in-house advisors are really well positioned, both to know the office's policy or regulatory priorities, but are also trusted partners. And they have a background that can help when reading the latest papers or announcements or engaging with companies. And the engagement with companies, I think, is important too. I mean, the reality is we're not seeing really good formal opportunities for engagement with regulators. And I think that's a powerful approach to education. Otherwise, we will end up only communicating through conference papers. Regulators could demonstrate more that they want to see the progress and understand. I mean, and I really appreciate the regulators that are here today, but I don't think an industry fora is enough. A session like this is useful in getting the word out to a large audience, but real education comes from regulators and policymakers engaging to show that they value the efforts and genuinely want to encourage them. Doesn't mean naming specific pets and regulations, that'll become dated, but qualifying the attributes of pets that help support their compliance activities. And really, here's what I've observed. In too many cases, regulators come at genuine pets from the direction that there has to be a catch, that the company's trying to hide something. I can take local differential privacy for an example. So local differential privacy is the version where the data is randomized prior to any collection. And in conversation with the Berlin group, the dialogue veered between it being supposedly obvious that this must be a shell game, because how can data that's randomized actually be useful, even though it is, or of being no value to a user's privacy rights, because anything arising from user action is for all of time the personal data of the user. And that leaves basically very little space for productive dialogue. I mean, as Boyana said, the notion of regulators valuing these steps when a company takes them is really critical. So yes, regulators need to ask the hard questions of companies, but they should also develop ways to identify cases where the desire and the use of pets to solve problems is genuinely done. You can call them privacy enhancing or privacy preserving technologies, but they don't eliminate risk. There's no absolute security or absolute privacy. Yet it's incumbent on the regulators, in my view, to highlight the positive views of the deployment of the technologies, and that can only arise through education.
Eric, really well taken. Just before we give Paul and Adeline a quick chance to respond, you mentioned regulators who joined. In addition to Paul and Adeline, we have a number of agencies who are attending. We're really grateful that you are with us. We see you, folks from the United States, from both FTC and from administration agencies, from Congress, from Hong Kong. I haven't mentioned you, and you're here. We appreciate it. I do want to give Paul and Adeline a quick chance to respond to anything you heard. Did it resonate or not? And then we'll move to the lightning round.
Yeah, thank you, Matthew. Yeah, I take all the points that have been raised. I think obviously we have published guidance on pets. We were the first data protection authority to do so, and I think that just lays the foundations for how pets can help with compliance with data protection law. I think there is more to be done, not just from other regulators, but from ourselves. And I think in the next phase, we are looking at how we can implement pets into other guidance. So, for example, guidance on AI, guidance on Internet of Things, guidance on cloud computing, and how pets can help mitigate risks in various types of use cases. So I think our pets guidance was the first step, but we're looking at that. We're also looking at increasing our number of case studies as well. We have a few case studies published on the guidance page at the moment, but we're looking on developing further case studies for other pets that we haven't covered so far. So yeah, I think that there's a lot more to be done, but I think the pets guidance and some of the work we've done so far is a good starting point for that.
Just a really important point you made when I sort of teed up the education question. I sort of presented it in one way of industry educating policymakers. And you made the very important point that it also goes the other direction, which is the sort of invaluable guidance that your agencies have provided. Now I'm going to call this lightning round. We had a number of questions in the chat about industry standards and how kind of where we are and where we need to go with standards for pets. The way I'm going to do this is actually give any of our panelists a chance to weigh in on this right now. What more can we do to advance industry standards in pets? And if you could just, do we have a panelist who might want to speak to that?
I'm happy to comment on standards on the underlying technology under the, for example, homomorphic encryption. We use this as if it was one specific term, but actually there are many types of homomorphic encryption, many implementations, and what I believe organization definitely for wider adoption would need to know that what they are getting from a vendor that they are working with is actually secure, and to which level, because even when we say secure, it's not, hermetically secure. Any technology has, some limits, and so I think standardization is important when you go for a broader adoption, and when you get technology like cryptographic techniques or other techniques, that you need to know that as an organization that it's actually what is the level of protection, what are the risks, and that it actually adheres to some standard of implementation of algorithmic standards and so on. So I think it is important to standardize the fundamental technologies. There are layers on top of them of solutions which will be pretty impossible to standardize, like databases. There are no really standards, but there are a common, for example, SQL is being used on many databases, but it's not a standard. It's like a de facto, very popular way of expressing queries to database. So what I'm basically saying, the fundamental technologies such as encryption, such as maybe multi-party computing, federated learning, the very low levels there can be standardized, and this will help adoption.
Thank you so much, Rena. My gosh, we are at the 1 minute mark. Certainly, this is the point where I think I need to say it, because we want to respect your time. Thank you so much to our panelists for your tremendous insights you've shared and for your time. We are so grateful. This project continues, right? This is not the end of it. This is, as Natasha's indicated in the chat, we have more publications coming. We want your engagement. We want your involvement. We want your feedback. Any other points from the CIPL team before we go? Great.
Just to say thank you, everyone, from my side as well. Thank you for the amazing input, and also thank you for everybody who wasn't afraid and stepped forward in the chat and post their questions and their comments.
Thanks, everybody. All right, with that, we'll wish you a good afternoon, good night, and good morning. All right, bye-bye now. Take care.